All right, let's jump right into this explainer of an absolutely landmark Supreme Court case. We're talking about a ruling that literally reshapes our entire understanding of magisterial power and police investigations here in India. The case is Sikiri Vasu versus State of Uttar Pradesh, citation 2008, 2 Supreme Court Cases 409. Now, if you've ever wondered what on earth happens when the police refuse to investigate a crime properly, or if you feel a local investigation is totally biased, well, this is the definitive case you need to know. It fundamentally takes power away from the lofty high courts and places it right down at the grassroots level. For all you law students watching, we're going to be using the classic IRAC method to brief this case so your notes are crystal clear. Here's our agenda. We'll start with the tragic facts, move to the core legal issue, look at the rules and statutes, cover the arguments of the parties, dive into the doctrine of implied powers, and finish up with a Supreme Court judgment.
Okay, Part 1. The tragic facts. The death of Major S. Vasu.
You know, to really understand the legal principles we're about to unpack, we have to first look at the deeply emotional, incredibly tragic event that triggered this massive legal battle. Because behind every great constitutional question, there's usually a very real human story. Back in August 2003, Major S. Vasu, who was an officer in the Indian Air Force, was found dead at the Mathura railway station. The military authorities quickly conducted a statutory court of inquiry, and they concluded that it was a tragic case of suicide. But the Major's father, Sikiri Vasu, absolutely vehemently rejected this. He alleged a massive cover-up, claiming his son was brutally murdered because he was about to blow the whistle on a major corruption scandal involving the pilferage of defense equipment. So totally dissatisfied with the military suicide ruling and alleging local police inaction, the father's quest for an independent Central Bureau of Investigation, or CBI probe, moved super fast through the judicial hierarchy. He filed a writ petition in the Allahabad High Court, which got dismissed, and that prompted him to file an appeal by special leave straight to the Supreme Court.
Moving on to Part 2. The core legal issue. Analyzing magisterial authority. This right here brings us to the absolute crux of this explainer, the exact legal question the Supreme Court had to answer to resolve this grieving father's plea. What is the exact scope and extent of the powers of a magistrate under Section 156(3) of the Code of Criminal Procedure? Specifically, does a magistrate actually have the teeth to actively monitor a police investigation to ensure it's done properly? Or must an aggrieved citizen just bypass the local courts completely and clog up the high courts via writ petitions just to get a proper probe? The answer to this literally changes the entire landscape of criminal procedure.
Section 3. Rules and Statutes. The procedural framework. All right, let's take a look at the statutory framework and see how this builds the whole foundation for the court's analysis. For the law students taking notes, you'll definitely want to pause and grab this technical breakdown. The court's interpretation of Chapter 12 of the CRPC directly maps over to the specific provisions in the new Bharatiya Nagarika Suraksha Sanhita, or BNSS, of 2023. So we're looking at Section 154 for information in cognizable paces, moving to the BNSS equivalent of Section 173. And most importantly, Section 156(3) of the CRPC, which is the power of a magistrate to order an investigation, translates to Section 175(3) in the BNSS. Understanding these statutes is absolutely crucial, because the court had to figure out whether the text of these laws limited the magistrate or actually secretly empowered them.
Part 4. Arguments of the parties. Appellant versus respondent.
Now, what's super interesting about the arguments in this case is the stark contrast in how each side viewed the power of local courts. The father, or appellant, argued the local probe was basically a complete whitewash designed to protect high-ranking military officials. His legal team argued that Section 156(3) is merely a triggering mechanism. Basically, in their eyes, the magistrate can order an FIR to be registered, sure, but after that they're completely helpless and totally lacked a jurisdiction to investigate complex crimes inside a military base. So, they said only the High Court can order a CBI probe. On the flip side, the state of UP neutrally countered that subjective dissatisfaction doesn't just automatically justify bypassing grassroots remedies. They argued the local police followed due process, and the appellant was bypassing the entire statutory hierarchy. They urged that citizens absolutely must exhaust local remedies before flooding the constitutional courts. Section 5. The Doctrine of Implied Powers. The court's reasoning.
Okay, this right here is where the legal magic happens. Justice Markandeya Kachu authored the judgment, and his reasoning provided a definitive, brilliant exposition on the hidden, extensive strength of the magistrate's office, using the doctrine of implied powers. It's actually a pretty simple concept. When a statute confers an express power upon an authority, it legally grants every auxiliary and incidental power necessary to make that express power fully effective. The Supreme Court essentially said, look, under Section 156(3), a magistrate is expressly empowered to order an investigation. But that doesn't mean the magistrate just signs a piece of paper and then becomes a passive observer. No way. The power to order an investigation inherently includes the power to ensure it is actually done thoroughly, impartially, and fairly. Because of this doctrine, the magistrate is not some helpless spectator. If the police are acting in bad faith, dragging their feet, or burying evidence, the magistrate actually has incredible operational scope to step in. They can direct the police to speed up the probe, they can order the actual registration of the FIR, they can call the investigating officer into court and demand periodic progress reports. If bias is shown, they can even order a change of the investigating officer within the local hierarchy, or, get this, order a complete reinvestigation. This effectively turns your everyday magistrate into an active, hands-on supervisor of justice.
But wait, what about the father's demand for the CBI? Well, the court reasoned that routine demands for CBI probes would completely overwhelm the agency's resources, right? That makes it an extraordinary remedy rather than an absolute right. A CBI probe is reserved strictly for exceptional cases, things involving national security, massive interstate ramifications, or systemic, high-level state corruption. So for everyday grievances about a bad police investigation, the High Court is actually not your first stop. Your local magistrate is.
Finally, Section 6, the Supreme Court judgment, the final verdict.
So, how did the court ultimately balance this grieving father's plea with the procedural law of the land? Ultimately, the Supreme Court dismissed the appeal and upheld the Allahabad High Court's decision. But while the Supreme Court denied the CBI investigation, they didn't just leave the father empty-handed. They firmly directed that he was granted liberty to immediately approach the relevant local magistrate under Section 156(3). And more importantly, they made it clear that the local magistrate must independently assess the case using their newly affirmed robust regulatory powers to make absolutely sure the local police conduct a fair probe. Let this precedent really sink in for a second. The local magistrate acts as the constitutional custodian of the investigation at the ground level. This is such a powerful precedent because it transforms the everyday magistrate from a mere administrative rubber stamp into a true shield for the common citizen against police inaction or corruption.